Right, so my name is Eirik. I'm a PhD candidate at the law faculty. I've been here now for about a year. So, I mean, so far so good. Still have about 3 years left of writing until I finish. And my topic is on offshore wind farm licensing in a comparative perspective. So I'm looking at UK governance and Danish and Norwegian regulation as well, and I'm comparing them. So the first half, I'm just going to provide some simple context. I'm going to talk about how much wind we currently have in the North Sea and some policy objectives in terms of how much deployment we could have of offshore wind by 2050. I'm also going to briefly mention the type of spatial footprint that offshore wind farms leave in the wake, and the concept of change, of course, which is the core theme for today's short presentation. I'm also going to briefly describe some very general comparable aspects of offshore wind farm licensing in certain North Sea states. And for the second part, I'm going to go more specifically into the regulation of environmental impact assessments, and more specifically the use of the Rockdale approach, which is a kind of method that developers use in describing the different effects that impact assessments could have. I'm going to have to speed through the first half because I'd much rather spend my time talking about the legal issues, which is in part 2. Right, so setting the scene. The concept of change. I'm looking at the concept of change, material and non-material changes. One can assume that environmental and socioeconomic parameters change over time, essentially. And this is particularly the case with the lifespan of offshore wind farms, which tends to be between 25 to 30 years, depending on the jurisdiction and the license itself. So between 2007 and 2014 alone, wind turbines doubled in size and capacity due to evolving technology, which was introduced onto the market. So new technologies also gives the state more flexible opportunities in selecting marine areas in terms of marine planning, with which to ideally place the wind farms, considering floating wind technology can reach deeper depths. So taking the concept of change into account, it becomes apparent that the regulation governing the licensing procedure must necessarily reflect values of flexibility alongside values of predictability as well. Right, so we currently have approximately 25 gigawatt of installed capacity in the North Sea. That represents approximately 79% of the European cumulative capacity. The average wind farm, and these are numbers that I got from Wind Europe, the average wind farm currently represents about 788 megawatts in capacity, and they are placed approximately 23 nautical miles in average from shore. And these numbers keep increasing for every single year that Wind Europe releases their annual report. So, and that is, of course, due to technological improvements, once going back to the concept of change. And the world's biggest wind farm is Hornsea 1, which is on approximately 407 square kilometers. That is approximately the size of Malta or the Isle of Wight. Then we have Hywind Tampen in comparison, which is just 11 square kilometers. It's a smaller wind farm, and it has a different purpose altogether. It's about 11 turbines, which will feed nearby oil and gas platforms with renewable electricity. So effectively, you have sustainable energy, which is used to produce non-sustainable energy. So welcome to Norway. In terms of the policy context, the European Commission has said that we could potentially have more than 300 gigawatt of installed capacity in the North Sea by 2050, but other Wind Europe has said that we could even potentially have 450 gigawatt. So this would probably meet around 30% of the EU's energy demand by 2050. So that kind of shows that there's political will across North Sea states to to increase deployment of offshore wind in the coming years. Right, this is just the spatial footprint that wind farms tend to leave in their wake. It tends to affect navigation routes and shipping, fisheries, military exercises, and the natural environment, of course, but this is largely limited to the construction phase, and of course, migratory animals, fish and birds, and other energy activities, of course, such as oil and gas platforms. Right, so this is just some very small comparison that I have between different licensing procedures in the North Sea. Anything that happens up until the tender procedure is essentially a very political process, whereas everything that happens after the tender procedure is more legal in terms of the licensing procedure itself, as it becomes project specific. And the principal decision is essentially one that reserves certain matters for subsequent approval. So it's, legally speaking, the implementing decision that gives the developer a right to actually construct and operate the wind farm. But what we are mostly concerned with is the environmental impact assessment, at least for the purpose of today's presentation. And the impact assessment tends to be conducted right preceding the principal decision, right after the developer has won the auction or the competitive process, which is the tender procedure. The open door procedure is not so popular. They have it under the Danish regulation, but it's never been used other than for pilot projects, I think. Right, so moving on. Environmental impact assessment. This is the main obligation flowing from the European directive, and an impact assessment essentially has a twofold purpose. Firstly, it provides information about the likely impacts of proposed projects of a proposed project on the environment, and secondly, it facilitates participation in decision-making procedures in line with the Aarhus Convention. So it plays a very significant and very important role in very much making these environmental decision-making procedures into a democratic process, in a sense, considering you have to involve affected parties, essentially, in consultations. So the substantive obligation is mentioned in Article 2.1 of the directive, and it essentially says that member states shall ensure that before development consent is given, projects likely to have significant effects on the environment. You have to prepare something called the impact assessment, whereby you have a significant likelihood of environmental effects flowing from the project. And Article 4.2 pertains to onshore and offshore wind farms in terms of Annex 2. So what that means essentially is that states can exercise a discretion as to what constitutes significant effects or not. But you know, a large scale commercial offshore wind farm is very likely to have significant effects. So the discretion doesn't really matter in that sense, I suppose you could say. And the directive is not necessarily binding on North Sea states anymore, that is, especially for the UK, considering you have Brexit. But it's still, you still have the environmental impact assessment regulations, which is still in force from 2017. So that is, by and large, still a copy-paste kind of version of the directive. So it's still harmonized with the directive, but you don't necessarily have something called the principle of direct effect from the union. Norway is not bound to follow the directive either, but surprisingly enough, we've actually gone even further than this substantive obligation, because there's no discretion when it comes to conducting the impact assessment for offshore wind farms in terms of the Norwegian regulation for the Ocean Energy Act from 2010. So we have actually gone even further. Right, so the Rockdale envelope approach. When you look into different impact assessments, you might see this being referred to as the design envelope as well, but it the reason I call it the Rockdale envelope approach is because it stems from a case from 1999 in the UK, which was R versus Rockdale NBC, which was split into two different cases. And this was actually a fairly interesting case. It concerned some outline planning permissions for a business park. And that business park consisted of a spine road, hotels, offices, and leisure buildings over some 50 hectares. So it was a very large development in a sense. But what it did not have was a sufficient description of the project on any level. It mainly had a very short reference to the master plan, the illustrative master plan. So on that account, it was challenged by the claimants, and naturally they won. But nevertheless, the judge, the residing judge in the case, said that the impact assessment, it possibly could not complete or have a complete description of the project, which was intended to evolve over the course of the next 10 years, thereby constraining the developer in a so-called legal straitjacket. So necessarily there had to be some kind of flexibility or leeway on part of the developer. So what the developer then did is that he went back to the impact assessment and he revised the description of the project, and he gave it a more accurate description. But what he failed to do was to provide a complete description of minor details such as the exterior design of the different buildings, for example. And then the judge famously said, if a particular kind of project is expected to evolve over a number of years, depending on market demand, there's no reason why a description of the project for the purposes of the directive should not recognize that reality. And so this judgment then gave fruition to the so-called Rockdale envelope approach. And the reasoning, essentially from a legal point of view, is that you can still use a wide set of different parameters in describing the different effects. And that is legal, it's fine. It corresponds with the main obligation in the directive, but you still have to describe the possible effects flowing from every single parameter that you are addressing. So I'll get back to what that looks like in impact assessments pertaining to offshore wind farms in just a second. Right, so assessing the likely effects of proposed wind parks based on a not environmentally worse than approach or a worst case scenario is actually a very well settled practice in both the UK and in Denmark as well. It was used in every single impact assessment pertaining to the round 3 projects. That includes the Hornsea 1 and 2, I think, if I'm not mistaken, Dogger Bank, Navitus Bay and Rampion as well. And the practice is also explicitly acknowledged by the Planning Inspectorate. That is the licensing authority in the UK for dealing with applications pertaining to nationally significant infrastructure projects in line with the Planning Act. And they have actually released guidance on how to use the Rockdale approach, but what it fails entirely in doing is on giving some kind of interpretive guidance on how you should set those appropriate parameters, which I'll get back to in a second. But what it does is that it affirms the Rockdale case, which is important for the sake of the legality of the method. Right, so what the Planning Inspectorate does, or the guidance note, is that it says that you can describe the likely effects from the proposed wind farm by essentially using wider parameters when you are describing the likely effects flowing from the turbines. You could have different sizes of turbines. You could have something, you can have a turbine which is 130 meters tall, or it could be 190 meters tall. It could be the nacelle height, that's the house on top of the turbine which houses the generator, which creates electricity. Could relate to the blade tip and the height length, could be the minimum separation distances between the different turbines, and it could also address, minimum clearance above mean sea level. So that then begs the question, how is it actually used? And I've brought some examples from the impact assessment, which pertains to Hornsea 3. What Hornsea 3 does is that it describes it from minimum and maximum parameters in relation to different layout scenarios. It says that, you know, you could either have layout scenario 1, 2, 3, and so on. It could relate to different kinds of infrastructure, grid connections, the commissioning timeline, and so on. I think it said that the maximum commissioning time would be up to 30 months, I think it was, which is a long time. Yeah, so what it does is that it chiefly addresses two different worst case scenarios, in which it describes the first scenario as consisting of 300 turbines, or it describes it secondly with 160 turbines. Yeah, so that's essentially the Rockdale envelope approach in practice. And that brings us on to some rather interesting issues. So while the Rockdale envelope approach may be seen as a necessary mechanism, at least so I think, in order to incorporate more flexibility into the impact assessment regulatory regime, the worst case approach is not without potential fault. And I think that the first issue, by and large, informs the other two. And the main issue is essentially that the wider parameters which the developer is allowed to use, it's not necessarily constrained by a particular threshold, which is imposed by law. So this can be viewed as an overarching issue, as the developer is permitted to exercise an unfettered discretion due to lacking regulation, essentially. So this increases the overall legal uncertainty in relation to the impact assessment regulatory regime, which in turn increases the risk of procedural errors in impact assessments, which could delay commissioning, for instance. And this is certainly the case at the project-specific level, as impact assessments pertaining to proposed wind parks may be denied in approval. That could cause a delay. But, you know, you still have some interpretative guidance in the UK, because if I'm not mistaken, developers, they can rely on former impact assessments which have been granted a so-called IEMA approval or quality mark, I think it's referred to, which to some extent at least suggests an approved practice. So that means you have some kind of precedence which you can rely on in terms of former approved practice. I'm not entirely sure how they do it in Denmark as of yet, but they too, by and large, uses the Rockdale envelope approach by describing the potential effects with wider parameters. And the second potential is at this stage theoretical, where the Rockdale approach allows a developer to base impact assessment parameters on worst case scenarios, and multiple developers apply such scenarios simultaneously within a larger area which has been opened for project proposals. Such worst case scenarios can effectively stack, creating an unrealistic outlook on potential cumulative impacts within a larger area. So where that is the case, the worst case outlook between impact assessments may entail that the potential impact on certain sensitive species, for example, exceeds a certain toleration limit, which means that the appropriate authority or the licensing authority will have to refuse subsequent applications. So on a planning level, this introduces a whole bunch of issues. So that means that unrealistic outlook based on those worst case parameters may implicate an issue at large in which the capacity for benefits of an area is not reaped at its full potential, you know, due to those realistic, unrealistic descriptions. Thirdly, we have some issues with regards to stakeholder participation in decision-making procedures. You know, arguably it makes it much more complicated, because what happens when you use these different parameters and you describe it with the worst case scenario is that you are essentially bulking up the impact assessment with much more content, which in turn is much more complicated for stakeholders to perceive or understand. So I think that was it for East Anglia, I think it was, but the impact assessment consisted of more than 36 chapters divided into 3 volumes. And when you have stakeholder consultations and you have to squeeze all that information into 3 months, or maybe even in some cases just a couple of weeks with consultations, it's not enough. So there's the worry then that ambiguous project proposals, as evident from the wide parameters, they are less likely to facilitate social acceptance, which is also a very big issue. Right. Yeah, this is just a brief example of what the potential issue could be in Norway, because we haven't done this before. But I suppose we could draw some regulatory experience from the UK and Denmark in looking into how this could be done. But in relation to the second issue that I just described, whereby the unrealistic descriptions effectively stack, that could be a very big issue in terms of Sørlige Nordsjø 2, or the Southern Northern Sea 2, which is right on the border to the Danish economic zone, because Sørlige Nordsjø 2 has been reserved for more than 3 projects. So I think it's been planned that it should represent more than 3 gigawatt in cumulative capacity. So this could very much be an issue for Sørlige Nordsjø 2. Likewise, it could be an issue for the UK development, the Hornsea projects, which are driven by Ørsted, which is on the due east of Yorkshire, I think, somewhere. So that begs the question, how do we then regulate the Rockdale approach? I think it's very likely that developers will set very wide parameters in order to reserve space for subsequent change. So as previously shown, this is very much, or could potentially be, an issue. So that begs the question then, how do we police its abuse? Is there truly a regulatory gap here? And there's a surprisingly limited amount of literature on this issue, which I think is rather surprising. Authors have suggested ways in which the consenting authority can implement preemptive measures in order to mitigate those potential risks of delay. But I actually think that you already have a kind of wording in the directive which can be used effectively to police the abuse. So I don't necessarily think that this is so much an issue, at least now. And that is this idea of reasonable alternatives in the directive. So Article 5.1 requires the developer to prepare and submit environmental impact assessment report. And part of that report has to address something called, or you have to give a description of reasonable alternatives. And describing different alternatives, it's a long-standing requirement in the directive, but the wording of reasonable alternatives is actually a very recent amendment, which came about in 2017, I think it was. So the previous wording preceding 2014. So the previous wording before 2014 was that the developer had to describe the main alternatives, I think the wording was. So that begs the question then, what the hell does reasonable mean? Because there's no exhaustive definition of the term in the directive itself. So it's somewhat difficult to actually discern what reasonable actually means. But I think that it could be used as a threshold for setting those wide parameters. Yes, so like I said, the previous wording was outlined the main alternatives. And while the interpretation of alternatives does not require an extensive legal analysis to prove the connection to the Rockdale envelope approach, if you look at Article 5, 4 in the directive, it essentially says that those alternatives can be interpreted as to entail different kinds of technologies, layout scenarios and whatnot. So that is by and large what the developer does when he uses those different alternatives. So that means that you can easily subsume, or rather connect, in a sense, the use of the Rockdale envelope approach to this idea of alternatives. So that's fine. The issue is with regards to the reasonableness term. There's no exhaustive definition to be found on the reasonableness term, but there has been prepared some guidance notes by the European Commission. This is, however, not legally binding, but it does have some persuasive value towards interpretation of the term. So it states that the alternatives envisaged in the impact assessment, it should accomplish the objectives of the project in a satisfactory manner, and should also be feasible in terms of technical, economic, political, and other relevant criteria. So in other words, where the alternative then is technically, financially, or legally difficult to carry out, you could interpret the alternatives as not being feasible in a sense. And it explicitly says that there may be budget obstacles to carry out the project. There may be strong stakeholder opposition to the contemplated alternative. There could be legal or regulatory obstacles which would prohibit the proliferation of the alternative. And there could be technological obstacles as well. So there's certainly some nuances that I'm trying to figure out in terms of those very short definitions. Such as, could you, for example, describe the likely effects flowing from future technologies, for instance? I think it was Arca Offshore Wind, they recently released plans of developing a underwater substation. Up until now, they have been above mean sea level. They've been used, they use jackup rigs in order to heighten them. So, for example, then could you base those parameters on future technologies which do not exist at the time of the application itself? So there's certainly some very interesting questions to address in that regard. Right, so there's clearly a need for flexibility mechanisms in the legal impact assessment regimes in individual North Sea states, as evinced by the concept of change. The Rockdale approach and its widespread use in the offshore wind farm licensing industry is very much a welcome flexibility mechanism, but we have to ensure that its use is adequately policed to promote legal certainty and prevent delays in decarbonizing the energy mix. So that's it, I guess. If you have any questions or you simply want to connect, I invite you all to get in touch. So there's my email, and I suppose that concludes the presentation. Thank you.